Now they've started.
Let me see both, actually. Thank you.
For the accurate representation.
These are subject to the complaint. This is what they're doing now.
I'm sorry, but I think the ones I gave you do not have those summaries, so maybe Mr. Hart's has the accurate ones.
The accurate ones, my, how interesting. So what was submitted? Something that was inaccurate?
Mr. Garza, can we stand there? Can you be quiet?
I can't speak to my microphone.
While you guys are getting that together, Member Pilpel had a question, but maybe.
A couple of questions and points. So I'm looking for the packet material, trying to keep this understood. This was before the task force on March 7th, and there was an order of determination starting on page 8 of the packet. I do see something on page 23 of the packet suggesting that the matter would be reheard in April. Can someone illuminate whether that happened?
That was a mistake, and it was subsequently withdrawn. That the error was not as seen, and as a result did not have to be reheard.
Fair enough, thank you.
Okay, here is the.
So we'll come back to you. Thank you.
Here is the agenda for October 6, 2011. If you look at the. Let me make sure I have the right one here.
Hold on, Mr. Hartz, we're getting our screens up.
Okay, this.
We can't see it.
Have it yet.
Can you continue asking your question? Thanks.
Sure.
While we're waiting.
Okay, so in the order on page 9, the task force found a violation against librarian Herrera. I do agree, at least in part, with Ms. Blackman that Mr. Herrera was not responsible for the minutes that Ms. Blackman or the commission is. Mr. Herrera is the librarian and the department head, but not the commission secretary charged with the minutes nor adoption thereof, which is the responsibility of the commission. To the extent that the task force found a violation in March, according to the previous paragraph, and consistent with 67.30, the task force at that time, I believe, should have made a referral under the ordinance because it had concluded that there was a violation at that time. Having not done so at that time, I believe would require the task force at this time to rehear the matter and find a violation or not find a violation and act appropriately. I don't believe, based on what's before us now, that we could make a referral unless we further found a violation. I don't believe that the violation the task force found in March binds the task force at this time to make a referral under 67.30.
Did you get that?
I would look to hear other views on that.
Was that, I was understanding that was a question. Is that a question or is that a statement?
It's a statement, but I'm happy to hear briefly from the parties about their view on the
Okay, number one, I've checked with the city agency if it's appropriate, and there are two issues. One is if you ask the library commission, they will say Ms. Blackman doesn't work for us, she works for the city, and therefore we're not responsible for her actions. I have checked with the clerk of the board, and she is a city employee, and as far as city government is concerned, she reports directly to Mr. Herrera. He is her direct supervisor and is the only person who has any authority to take any action in relation to her performance. The Library
Yes, it's known as a
Commission
double bind.
cannot take any action in relating to her performance. All they can do is recommend to Mr. Herrera what they would like him to do, and then he does it. So basically, he is the one who gives her direct orders, and the Library Commission can tell her anything they want, but it is Mr. Herrera's job to ensure that she is complying with the ordinance as her direct supervisor. And he is also the person, and this has come up before the Ethics Commission, it is also the Ethics Commission's position that because the Library Commissioners are not elected officials and don't fit under the definitions in the ordinance, that only Mr. Herrera is a person who can be held accountable because he is the person who signs the Sunshine Declaration, takes the things, and is therefore responsible to see that the law is followed.
Do you want to comment briefly on the rest of the
Like I
statement?
said, the Ministry of Sunshine, where
Which
everything is
was?
obscured.
Whether or not the task force.
Here,
needs
Mr.
to
Hartz is telling the
review-
full truth, the whole truth.
They heard it in 10054, 11054. I mean, basically, this is simply another complaint of continued ignorance of prior rulings. In other words, what you're asking me is, if they just keep doing it over and over and over and over and over and over and over again, do I have to keep coming here and filing another complaint and hear it again, and another complaint and hear it again, and another complaint and hear it again? This was decided in 10054, 11054. Even the Ethics Commission has started to include my 150-word summary in the body of their minutes.
Thank you.
But Mr.
Now,
Papao would
Meg,
still prefer to redo it.
Well, we have one, does Ms. Black, do you have any comment? No. So then we can look at the document. Oh, we don't have it set up yet.
I just wanted to respond quickly to what Mr. Hart said. I am an at-will employee. I do report directly to the Library Commission. They hire and fire me. Mr. Herrera is my day-to-day supervisor, signs my timesheet, that sort of thing. But as far as the minutes are concerned, if the Library Commission directed me to do the minutes in a certain way, and Mr. Herrera told me to do it some other way, I would follow the direction of the Library Commission.
Contrary to what the clerk of the board told Mr. Hartz.
While we're waiting for, I'm sorry.
And perhaps Mr. Reed, do you want to respond? Hey. Do you want to respond as to whether or not the task force needs to hear this again on the merits, or needed to make the referral at the time and found a violation pursuant to 67.30?
Through the chair, I believe that the task force has made its decision about this violation and directed in the order that the Library Commission should proceed in a certain way. The question before the task force is whether they've done that or whether they've continued to the practice that was found in violation. If the task force finds that, excuse me, continued the practice that they found in violation, they may refer it.
Thank you. Mr. Hartz, can you show us? Thank you.
Okay. These are the minutes for October the 6th, 2011, which were one of the items in the subject of this complaint.
Thank you.
In the body of the minutes, under item number 7, you have a summary which was written by Ms. Blackman. And at the bottom it says, see addendum for summary of the comments submitted by the speaker. And then you have to go back to the end of the addendum to see my comments. And basically what they want is they want to have it both ways. They want to be able to put in their version of what I said in the minutes and put my version of what I said as an addendum. And even now,
So did they, I'm sorry, while you're doing, did they put your, kind of a summary of what you said in the body of the minutes and then did this amendment?
yes,
So there's two things that we're getting.
right. And very honestly, I've got dozens of examples, and it's very often that they don't really agree. What I
It's
said
the
and
same
what they
thing that
say I
happens in
said
Sunshine.
didn't. In
If you
fact,
listen
when
to the
this first
tapes, what
started, it
happened,
was the
in
simple
my
fact
case, it's
that,
the exact
like
same
under the
things that
Brown Act,
happened in the meeting.
the whole idea is you're not supposed to be able to censor
The minutes are different than what the
critical
meetings
comment,
happened.
and that's exactly what they did. They would
Listen to
put
the
in what
tapes.
they wanted to appear in the minutes,
Read the
and
meetings.
then leave it out, which is why
I
I've
mean the
been
minutes.
fighting this fight.
The clerk does the
Now,
same
what they
thing
have
here
started
in
to
Sunshine.
do,
This is since it's gone to compliance amendments, and you guys spoke, this is what we've gotten now.
right, well, the cases you're looking at right now that I just showed you are repeated violations of the prior orders. In other words, I just said, okay, you know, you've ordered them twice, they've refused to do it, they're still not doing it. Here's 3 more cases where they didn't do it, and this is another violation,
Okay.
okay?
Which won't be
Now,
sent up
what
to
they have
ethics because the
done-
city attorney disagrees. And all they have to do is say they have different city
Is
attorney
they
advice to
started
cover their ass.
include my summary there and then put additional comments in. And really, the whole idea is here, why should members of the public be put in a position of trying to figure out how the heck they're going to deal with these things? There ought to be a consistent pattern. And very frankly, I don't care what Ms. Blackman says. If she puts down her